Order, order. I call Sandy Martin to move the motion.
Thank you, Sir George, and it's a pleasure, as always, to serve under your chairmanship. I beg to move that the House has considered a review of decision-making powers of the Criminal Cases Review Commission. The Criminal Cases Review Commission, which I will refer to as the CCRC, was founded in response to the situation in which a number of high-profile criminal cases had led to people being in prison for crimes which the consensus amongst those who'd considered the evidence suggested they could not possibly have committed. Amongst those was the case of the Birmingham Six. Despite the intervention of lawyers, television, new evidence and the Home Secretary, the Court of Appeal managed to reject the appeals of the Birmingham Six on a number of occasions before the overwhelming evidence that their convictions were unsafe finally prevailed at their third appeal. As that case was one of the major motivating factors for the introduction of the CCRC, we should now expect that at the very least, the CCRC, as it is now constituted, would have been of help in resolving that case. My fear is that, on the contrary, its very existence is now making it less likely that such grievous miscarriages of justice will be resolved in future.
Bringing this to Westminster Hall for consideration, bearing in mind that just 0.7% of cases received by the Criminal Case Review Committee were referred to the Court of Appeal in 2017, its lowest ever rate. Would the honourable member agree that there's a valid question of the effectiveness of the current protocol, and this does need to be urgently reviewed?
I thank the honourable member for that intervention. He's absolutely right, and I will be coming to expound on that later on in my speech. I'm raising this issue here today because the case of my constituent, Oliver Campbell, is a classic example of a devastating miscarriage of justice for the resolution of which the CCRC appears to me to be more of a hindrance than a help. Oliver was convicted of murder in 1991 and spent 11 years in prison. Oliver is here with a friend so that he can hear this debate. He knows that I'm not being rude when I say he has a low IQ. He knows that this is as a result of a brain injury he sustained as a baby. This reduced mental capacity should have been evident to everyone involved in this case from the moment of Oliver's arrest in 1990, some 2 months after the murder of an Asian shopkeeper in Hackney. I've known Oliver for about 10 years. I think that anyone meeting him would come to the same conclusion as myself, as the BBC's Rough Justice team, as Michael Birnbaum QC, as Oliver's long-standing solicitor Glyn Maddox, and as the distinguished broadcaster Kirsty Walk have come to, that Oliver simply wasn't capable of carrying out such a crime. Oliver was arrested because witnesses identified one of the two men who carried out the robbery, during which the shopkeeper was killed, as wearing a distinctive baseball cap. The other man, Eric Samuels, was relatively short, and the witnesses also described the two men as being of similar height. Oliver is a large 6'3" man. Oliver was questioned for several hours in the police station without the presence of an appropriate adult, which he should have had due to his impaired mental capacity, and also without a lawyer present. A lawyer was eventually found, but it was only after the lawyer had left the police station, leaving clear instructions to be called back if there was to be any further questioning, that the police, in direct contravention of this, pressed Oliver in the presence of his ex-foster carer, but no legal representative, to confess. Within half an hour of persistent suggestion from the police, Oliver had confessed to a murder which I do not believe a reading of the evidence could possibly suggest he had committed. Many of Oliver's answers are bizarre and make no sense whatsoever. It is hard to understand how they could ever have been relied upon. Oliver's lawyer was then called, and Oliver immediately withdrew his so-called confession. Oliver was, however, convicted almost entirely on the basis of this very dubious confession in December 1991, and he served 11 years in prison. There was no forensic evidence linking him to the baseball hat, nor to the scene of the crime. None of the fingerprints nor hairs recovered from the scene, nor from the hat, matched those of Oliver Campbell. His co-accused, Eric Samuels, who admitted taking part in the robbery, said in interview that Oliver had nothing to do with the murder and was not at the scene. However, This information was never put before the jury in evidence. Samuel's statement was never signed, and Samuels refused to take the witness stand. Samuels was subsequently tracked down and interviewed by the BBC Rough Justice programme for their 2002 programme If the Cap Fits. He was filmed during their investigation and described once again how the cap was taken from Oliver's head by the man who was actually his accomplice, the man who was actually the murderer, and how it had been dropped near the shop. Samuels again refused to sign a statement, this time on the advice of his key worker. A ballistics expert was also brought in by the BBC, who established that the murderer would have had to have been right-handed. Experts have shown that Oliver favours his left hand for most tasks. Oliver's bizarre confession apparently includes details of how he made a holster out of string for the gun, and how he'd gone practice shooting in a forest or a field, but he couldn't tell the police the location or even whether it was a forest or a field. He was pressed to identify how many bullets he had had and how many were fired, but clearly had no idea what the correct answer to either of those facts was. After the BBC's Rough Justice programme, detailed and extensive submissions were made to the Criminal Cases Review Commission by Oliver's legal team, including his solicitor, Glyn Maddox, and his eminent QC, Michael Birnbaum, with the clear hope and expectation that the Commission would refer Oliver's case back to the Court of Appeal. After 2 long years, the CCRC concluded that there was nothing new to form the basis of a fresh appeal, and therefore no appeal. This was despite a recent change in the law which now enabled the Court of Appeal to rely on the statements Eric Samuels had made in which he completely exonerated Oliver. The CCRC also ignored the reports of 2 very eminent psychologists who explained Oliver's acquiescence to police questioning due to his limited mental capacity and his eagerness to please and to be accepted. As Kirsty Walk reported at the end of the Rough Justice programme, this evidence of Oliver's mental state, which had never been brought before the jury, constituted fresh new evidence which points to a terrible miscarriage of justice. I'm bringing this case to the attention of the House for 2 reasons. Firstly, of course, because I believe Oliver to be innocent of the crime of murder. Life is not easy for Oliver. Life would never have been easy, even without a murder conviction hanging over him. Oliver works 5 mornings a week at a community cafe as a cleaner. The rest of the time he spends trying to clear his name. But also, and crucially, the reason for us to have this debate here today, because the Criminal Cases Review Commission was established by this House to make it easier to rectify miscarriages of justice, and I do not believe that it has achieved this. I'm happy to give way.
He and I were founding members, as he knows, of the new all-party parliamentary group on miscarriages of justice, and of course he knows that we now have a commission on on miscarriages led by Lord Garnier and Baroness Stern. And does he believe that we need a fundamental change of the Criminal Case Review Board, both in terms of its structure and resources?
I thank the honourable member for his intervention. He's absolutely right, and I was very pleased to have gone to the first hearing of the Westminster Commission on the role of the CCRC just the other day. I think they're making good progress, and I hope to see a radical change in the way that we deal with appeals on the grounds of miscarriage of justice. The grounds for an appeal, in this case, in my view, are compelling. I'm not a lawyer, but I have an inquiring mind, and the first 3 grounds submitted by Oliver's lawyers seem to me to constitute essential issues which cry out to be reconsidered properly by a court. Ground A, the admissions made by Oliver in his so-called confession were inconsistent, inaccurate when compared to the rest of the evidence, and, on a number of points, simply absurd. Ground B, the report of Professor Thomas Peter, a well-respected and highly experienced psychologist, whose report states that Oliver's, lack of mental capacity for understanding anything other than the simplest of questions indicates to me that he would be vulnerable to self-incrimination. He added that Oliver had difficulty understanding double negatives, and that from his reading of the available documents it seems that part of Oliver's defence was based upon his succumbing to intimidation rather than his inability to understand complex questions. And ground C, police misconduct. I would very much like to believe that the treatment Oliver received at the hands of the Metropolitan Police would not happen today. Oliver was not treated appropriately and consistently in relation to his obvious needs and inabilities. He was questioned without solicitors. He was misquoted back to himself by the officers in order to confuse him. References were made during the interview to fingerprints on a can of lager held by the murderer being Oliver's, which was not the case, and which the police knew not to be the case. If the prints were Oliver's, they would certainly have been cited in the prosecution's case. If they were not Oliver's, then the fact that they belonged to someone else ought to have been enough to acquit him. But this evidence was never brought to the attention of the court. There is still no forensic evidence to link my constituent to this murder. Very briefly.
We agree that in some criminal justice systems, access to all the evidence that was presented at the trial on either side makes it much easier to look at the case later and to mount an appeal. Wouldn't he believe that that's something we should have in our country?
I absolutely agree with my honourable member. I thank him for his intervention. As far as I can tell, any criminal justice system which does not allow all the evidence that exists to be available to both sides of the argument prevents the correct decision-making being made in the court. I believe the Commission needs to look again at Oliver's case. I believe that if they reread the submission from the QC carefully, they will conclude that there is indeed good cause to send this case to appeal. The recently established APPG on miscarriages of justice has gained a great deal of support in this House. Oliver's pro bono solicitor, Glyn Maddox from Gabb & Company, who has represented Oliver for over 20 years and who is a recognised expert on miscarriages of justice cases, is a special advisor to the APPG. He's been working closely with the newly established Westminster Commission on Miscarriages of Justice, co-chaired by former Solicitor General Lord Garnier QC and Baroness Stern. Will the Minister confirm whether the Government will give its full support to the Westminster Commission as it undertakes this very important work? The purpose of the Westminster Commission is to look at the difficulty in overturning wrongful convictions in England and Wales. Such a review, in particular of the CCRC and its relationship with the Court of Appeal, is long overdue. I am hoping to have an opportunity to submit the failings of the CCRC's review of Oliver Campbell's case as evidence to the Westminster Commission. We need our justice system to be fit for purpose, to identify and punish the guilty and to exonerate the innocent. And where there is clear evidence that that has not happened, we need to know why. However, we also have a fellow human being to consider here as well. As a man who is still living under licence, with barely enough income to survive and subject to recall to prison at any time, I strongly believe that Oliver has had to wait too long already to have his name cleared. I urge the Minister to write to the CCRC to ask them to review Oliver's case once more as soon as practicably possible and to reconsider their decision not to refer his case back to the Court of Appeal. No one doubts that the job of the CCRC is difficult. It is being constantly asked to do more with less resources. I suspect that when it was set up in 1997, it was never expected that it would receive 1,500 applications each year. In its 22 years of existence, it has reviewed nearly 24,000 of the 25,000 applications it has had, many of them completely ineligible. Of these, the Commission has referred 658 cases to the Court of Appeal, of which all but 10 have been heard in the courts. 437 convictions have been quashed and 198 appeals dismissed. It is beyond me and anyone else who knows anything about this case why Oliver's case was not one of the cases referred. But does the Minister agree with me that that rate of convictions quashed suggests that a large number of the cases which have not been sent to the Court of Appeal might also have led to convictions being overturned? There is some concern about the subordinate relationship the CCRC has with the Court of Appeal and with the difficulty it faces in applying the real possibility test which it currently uses to decide which cases to refer. What I have personally seen with Oliver's case is that the CCRC has acted somewhat more as an arbitrary gatekeeper rather than as a champion for righting the obvious miscarriage of justice he has suffered. Oliver will be 50 next year. He's been fighting to clear his name for nearly 30 years. Those within the criminal justice system that have had contact with Oliver professionally, including from his time in prison, have had very serious doubts about his conviction. The governor at Wandsworth described him as a very low intelligence and childlike in some ways. Knowing him as we do, it is difficult to see how he has ended up in this situation. His probation officer said he had serious concerns about his conviction for murder. Even the trial judge's report to the Home Secretary at the end of Oliver's trial reflected his view regarding the gross artificiality of the result and the unsatisfactory nature of the trial process that led to it. I think it is right that I should pay special tribute to Oliver's legal team. His solicitor, Glyn Maddox, and his QC, Michael Birnbaum, both of them have worked tirelessly and resolutely to achieve justice for Oliver over 20 years and on an entirely pro bono basis throughout. Such dedication is rare, but at a time when legal aid is almost non-existent and miscarriages of justice are increasing, surely linked to cost pressures in the criminal justice system, it is an absolutely precious commodity. I very much hope that many other younger lawyers will be inspired to work on cases such as Oliver Campbell's. Several people have said that Oliver Campbell's case is the clearest example of a miscarriage of justice that they have seen. I'm surprised and dismayed that the Criminal Cases Review Commission, established by this House with all party support following the recommendation of the Royal Commission on Criminal Justice under the Major Government, has failed to enable the correction of what is such a clearly wrongful conviction. And I call on the Minister to institute a review of the CCRC's decision-making powers.
The question is that this House has considered the review of the decision-making powers of the Criminal Cases Review Commission. Minister.
Thank you, Sir George, and a pleasure to serve under your chairmanship. And I'd like to congratulate the honourable member for Ipswich for securing this debate on the decision-making powers of the Criminal Cases Review Commission. And like him, I think, for brevity's sake, I'll refer to it as the CCRC in my remarks. And I also thank him for explaining and setting out Oliver Campbell's situation. He is a forceful champion for his constituent, and indeed for his constituency. I know that, and I pay tribute to him for that, just as I do to the honourable member for Huddersfield for his commitment and dedication on this issue. I must be a little bit careful in paying tribute. As a reshuffle looms, I'm not sure whether it will help or hinder my career prospects by paying such fulsome tribute to members of the opposition, but the work they have done is truly impressive and important. And although the honourable member will appreciate that it wouldn't be appropriate for me to discuss an individual case on the floor of the House, I do welcome the opportunity to discuss the broader issue, and should he wish, I am of course happy to discuss it with him outside of this chamber if he feels that's helpful to him. As he's set out, Sir George, the independent CCRC plays a vital and valuable role in maintaining confidence in the criminal justice system. And in addition to my tributes to members in this chamber, I pay tribute to the commitment of the CCRC commissioners and staff to their work in investigating potential miscarriages of justice. And I am sure that all members, both in this chamber and beyond, will share my view that miscarriages of justice are a blight on our criminal justice system, have a devastating impact on all those involved, and can cause people to question that justice system, which is something we must at all costs seek to avoid. Since the establishment of the CCRC in 1997, I think I'll raise the honourable gentleman by 4. My understanding is 441 referrals now from the Commission have succeeded in the courts, which has resulted in overturned convictions or amended sentences. And, yeah, of course.
The Minister's always been very supportive and listened very carefully to everything we've been campaigning on this. So I appreciate that. Some of us went to visit the Commission in Birmingham. And we got the opinion they were under-resourced, they can't get investigators because it's right out in a limb in Birmingham and should be close to the centre of legal affairs in our country here in London, and also that commissioners very often are part-time and work from home. Didn't you think there's a bit of a problem there?
I'm grateful to the honourable gentleman. I suspect that some of his colleagues representing Birmingham seats might slightly take issue with his suggestion it is out on a limb. However, we believe that the approach adopted by the commissioners allows for flexibility in the most effective management of caseloads, and I'll come on to the tailored review in my remarks shortly. And in my discussions with the new chair of the Commission, my understanding from her is that she felt that the resourcing was adequate and appropriate, but that there are changes needed to reflect the findings of the Taylor Review. But I'll touch on those in my remarks, subject to time, in a moment. The CCRC is, as the Honourable Member alluded to, the world's first statutory publicly funded body charged with the task of reviewing alleged miscarriages of justice. And as has been mentioned, the law provides the Commission can only refer cases to an appeal court when it considers that there is a real possibility that the conviction, verdict, finding or sentence would not be upheld were the reference to be made. Now, I know that there are concerns which the Honourable Member and indeed his Honourable friend have set out about the real possibility test and whether it affects the rate that the Commission refers cases to the appeal courts. Now, the Honourable Gentleman has asked whether the rate of convictions quashed suggests that a large number of the cases which have not been sent to the Court of Appeal might also potentially have led to convictions being overturned. Now, these are concerns which have been aired before and were considered by the Justice Select Committee in its report into the CCRC published in March of 2015. The committee did consider whether a declining rate of referrals was due to the real possibility test, CCRC's application of it, or the Court of Appeal's own approach to appeals, and found no conclusive evidence of the CCRC failing to apply the existing test correctly. Neither do we feel would it be appropriate to alter the test simply to demonstrate the independence of the CCRC, and doing so would, by definition, risk allowing referrals where there was less than a real possibility of a conviction or sentence being overturned. The Select Committee accepted the application of the test is a very difficult task and is by no means a precise science. But where potential miscarriages of justice are concerned, the Select Committee did consider that the CCRC should be willing to err on the side of making a referral. I am assured that this is the approach CCRC adopt. There must be a realistic chance of success. However, the Honourable Gentleman, I believe both Honourable Gentlemen, referred to the work of the Commission that has recently been set up, and I'd make two comments on that. Firstly, as well as discussing Oliver's case, if the Honourable Gentleman would like, I fairly regularly meet with the Honourable Member for Huddersfield. He's very welcome to join in those discussions about the broader issues. But in terms of the Commission, I look forward to following its work, as the Honourable Gentleman has alluded to. Without making firm commitments, I hope he will recognise that I will always, and have always since I've been in this role, been willing to engage constructively, and I look forward to doing so. And of course, I'll give way to him.
Sir George, the people we met are really good people. I didn't want to denigrate them at all. They're very good people, under-resourced. And I got the feeling, talking to them and talking to people in this area, senior people in the judiciary don't like this system and they're not very positive towards it. Is that the real key, that some senior judges really don't like this process at all?
Yeah. The Honourable Gentleman is an experienced member of this House and is gently tempting me to speculate on areas where I will not tread. I would say that I believe the judiciary has full confidence in this process and fully respects the nature of the process, and that is reflected in how it engages with the CCRC and the appeals process. So he may seek to tempt me, but I fear on this occasion he may not have succeeded. I do also note that the CCRC's own analysis has identified other reasons for the recent level of referrals, including the lack of common themes across recent cases and changes in approach by investigators. The CCRC continue to review the reasons for a low referral rate, working with practitioners and academics to make sure they are aware of any potential new causes of miscarriages of justice. In February this year, the Ministry of Justice, as the Honourable Gentleman will be aware, published a tailored review of the CCRC. Now, that review found that the current delivery model as an NDPB is still, in our view, the most appropriate. The review did, however, make a number of recommendations relating to improving the Commission's performance. These recommendations were in part informed by respondents to the call for evidence, who commented the Commission, in their view, does not provide as timely a service as they would have wished. And the Commission has acknowledged that, although internal targets were met, too many cases were taking too long to resolve and more can be done to avoid delay. Now, the Honourable Gentleman has raised the amount of time, or alluded to the amount of time it's taken the CCRC in looking at Oliver's case and the handling of that. Now, the review team found that a single commissioner or committee of commissioners were making the decisions on the non-referral of cases, despite legislation providing the option for these decisions to be made by one or more employees of the Commission. And the review recommended responsibility for the final decision on non-referrals of less complex cases should be made by case review managers rather than commissioners. Now, I'm not concluding just yet. Go on, very quickly.
We understand that many of us got into this because we, myself in Huddersfield, had a really tragic case, like Oliver's case. And does he realise that even when someone 18 years in prison comes out, found not to have ever committed the crime, gets nothing when they leave prison?
Yeah. The Honourable Gentleman makes a very powerful point. He's made it to me in our previous conversations. I look forward to picking that specific point up in more detail with him. I think we're due to meet again for one of our regular meetings soon. A final point before I move on. In Oliver's case, as with any case, the CCRC would welcome an application to review Oliver's case if new information can be provided, and that would be decided by people who have had no previous involvement in the decision-making. Yeah, of course.
Well, thank you, Minister, for that. But if the CCRC say that there has been no new evidence and refuse to take any further applications, then what is our recourse after that?
Well, my understanding is that beyond that, the recourse is potentially via judicial review, which I appreciate is a complex and expensive process. So that's why I'm very happy to meet with the Honourable Gentleman following this debate to discuss this in more detail outside of this place. The review, as he'll be aware, also recommended that the CCRC and my department should discuss the possibility of changing the law so the Commission does not have to consider cases dealt with summarily and sentence-only cases. And the CCRC, I should say, currently considers applications relating to summary offences, often originating in magistrates' courts, as well as more serious indictable offences which are dealt with in Crown Courts. It considers also applications that allege that a person has been sentenced incorrectly. The review recommendation reflects the outcome of the JSC inquiry in 2015, which recommended the CCRC be given discretion to refuse to investigate cases dealt with summarily if they deem it not to be in the public interest to investigate. CCRC are considering and reflecting on this recommendation, but are of the view at this stage that the Commission should retain its function with regard to summary cases, given this is an area where miscarriages of justice can and do occur. It has established a working group to consider the recommendations of the Taylor Review, and I look forward to the outcome of their considerations and their discussions, especially on what can be done to ensure Commissioners can focus on more complex and serious cases. Now, I very much support the work of the CCRC, and I would, in saying that, recognise that in no way was I suggesting that the Honourable Gentleman does not, and I want to put that on the record, because I know he is deeply involved with this here. I know he has a lot of respect for the staff and their work, and actually, although I know he is courteously challenging of them, I know that the CCRC actually very much welcome his engagement with this. It shines a light on their work, it raises their profile, and I think that they enjoy and respect his interest and the focus it brings to their work. So I know that they want me to say that to him. With the appointment of 6 new commissioners in June, the organisation is well placed to deliver its important work investigating where people are wrongly convicted or where convictions are unsafe. And going back in my concluding remarks to the Commission, as I said, I look forward to considering very carefully the results of the work of the Westminster Commission set up by the APPG. As I say, as long as I am in this post, and I hope I will be by this time next week or this time in a fortnight hence, I hope he will recognise that while we may on occasions disagree, I'm always happy to engage with him and with honourable members across the House on this matter, and I will do, of course, on this particular issue. The Honourable Gentleman, Sir George, is absolutely right, as he has done, to use his position in this House as a champion for his constituents, to highlight Oliver's case, to bring it to the attention of me as a minister, but also more broadly, and I look forward, should he wish, and should I still be in this role, in a couple of weeks' time, discussing that with him and whether he wants to unpack some of the more detailed points he wished to make on that. It's been a pleasure, Sir George, to respond to this debate. I believe the CCRC continues to play a vital role in our justice system, both for individuals but also in upholding the integrity of our justice system, which is so precious to us all.
The question is, has considered a review of the decision-making powers of the Criminal Cases Review Commission? As many of that opinion say aye. Of the contrary, no. I think the ayes have it. The ayes have it. Order, order. The sitting is suspended until 2:30 p.m.